today. Please welcome.
Good evening. I guess it's already evening. Good evening, everyone. And thank you so much, Shaza, for willing to be the host for today's event. To my fellow friends at international and fellow students and friends at the International Law Unit, Nadira, Hassan, Hakim, and Dali. I saw Dali just now. Thank you so much for organizing this on behalf of me, doing this for International Law Unit, and also for your juniors, I guess, who is taking public international law course this semester. I would like to also extend my welcoming remarks to a friend of mine, Muhammad Ridwan bin Talib, an advocate and solicitor all the way from Melaka, joining us today to listen to the talk by our respected and favorite lecturer, Dr. Farid Muhammad Hassan. Okay, so he will be taking over this subject from me, this immunity, the topic on immunity. Solely, he will be taking it over from you because he has requested to me at the very beginning of the semester that he intends to share his knowledge and also experience because his PhD is actually on that. So I guess he's the best person to do that. I hope everyone here could take this opportunity to ask him lots and lots of questions because he has lots and lots of things to share with you with regards to the topic that he is delivering today. Right, again, thank you very much to all my students who are joining this program today, and those who are affected by the floods. I hope all is well with you. And if you cannot join today's event, Sister Nadira here will record this and put it on YouTube for you to watch it later. So back to you, Shaza. Thank you very much. And I would like to again welcome Dr. Farid to our event today. Thank you.
Thank you, Prof. Hasmi, for the all-inspiring speech. Now, before we begin with our session, allow me to briefly introduce you our incredible and honorable speaker, Dr. Farid Muhammad Hassan. Dr. Farid Muhammad Hassan holds a PhD in law from the School of Law, University of Aberdeen, Scotland, United Kingdom, a Master of Comparative Laws from Ahmad Ibrahim Kuliah of Laws, International Islamic University, Malaysia, and a Bachelor of Laws in Sharia, LLB and Sharia, with honor from University Science Islam Malaysia, USIM. He is currently a senior lecturer at the Faculty of Sharia and Law, USIM, specializing in international criminal law and international criminal justice system. Being an expert in the Rome Statute, which establishes the International Criminal Court (ICC) at The Hague, the Netherlands, he has advised the Conference of Rulers in Malaysia on the issue of Malaysia's accession to the Rome Statute in 2019. He has also contributed in preparing a written submission to be submitted to the ICC in establishing the court's jurisdiction over the alleged crimes committed by the Israelis against the Palestinians in 2020. On February 2021, this year, the ICC has decided in favor of the state of Palestine as submitted. Now, with all of these experiences being said, let's call upon Dr. Farid Muhammad Hassan to proceed with our talk this evening. The floor is yours. Please welcome.
Hi, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh. Before I begin, am I audible?
Yes, loud and clear.
Thank you. Now, before I begin my lecture this evening, so allow me to thank to my learned brother, Associate Professor Dr. Muhammad Hazmi Muhammad Rasli for kindly organizing this special lecture to be given by me, and also the organizing committees for preparing and also for helping to realizing this event this evening. And also I would like to warmly welcome all of you to this lecture this evening, although it's not really conducive to have a lecture on this very heavy topic at this time at 5 p.m. So it will be very sleepy, I guess, because the topic is quite heavy and challenging to be absorbed by everyone, but I'll try my best to explain the topic very briefly to all of you. Now, without further ado, I'd like to share the screen right now. Can you all see my shared screen?
Yes.
Thank you. Now, as explained by Miss MC just now, that the topic that I would like to share with all of you today is with regard to the topic of jurisdiction and also the immunity under international law. So these will be the outline for the lecture. And I will first start very briefly to discuss on the definition of jurisdiction. So now, basically jurisdiction is based on two types. Number one is it is based on state jurisdiction, and also number two is based on courts or tribunals jurisdiction. So for the first part on state jurisdiction, it deals with the issue of whether or not the state has legal competence over a case in order to make and also to apply as well as to enforce rules or laws with regards to person, property, situations, and events, either within the limits of its competence or outside its territory. So all in all, state jurisdiction means that whether or not the state may apply and enforce its law, right, within the jurisdiction, or perhaps whether the laws or the decisions of the court, or whether the state jurisdiction may be applied outside the state territory. Now, on the second, on state jurisdictions, I would like to expand more on this point, whereby the state jurisdiction is basically very fundamental, right? Because it has a close relationship with the concept of state sovereignty. Because when a state may exercise jurisdiction, so it shows that state is sovereign over that particular territory. So this the concept of state jurisdiction and also state sovereignty concerns both the extent of sovereign powers, right, the authorities of a state, and also the scope and limitation of those powers at the international level. Now, under international law, state jurisdiction equals to state sovereignty. So this state sovereignty under international law is known as par imparem non habet imperium principle. Right. So what does it mean by par imparem non habet imperium? Right. This Latin word connotes that one state cannot take measures or cannot exercise jurisdiction on the territory of another state, which means that State A cannot exercise its jurisdiction over the territory of State B or State C, right? And State A cannot enforce its law on the territory of another state. So this is has been established under the concept and principle of par imparem non habet imperium under international law. Now, state territory also to be discussed and to be divided into a number of territories, right? So what are these territories? I will further elaborate on this part later on, but I will just briefly explain to you in this slide. So state territory is divided into a number of situations. Number one is land territory. So this land territory means the land or the territory where the state possesses or owns, right? And also the subsoil, whatever underneath, and also whatever above the land, right? The airspace. So this includes the internal and also national waters, whatever waters within the territory. So these are considered as land territory of a state. Number two is maritime territory. So this is also territory of a state under international law. which has been prescribed 3 of the United Nations Convention of the Law of the Sea, 1982, on territorial sea, whereby from the coastline until 12 nautical miles, so it will be considered as state territorial sea. So within this 12 nautical miles, it is still considered as part of state territory under international law. And number three is that the airspace, right? So airspace is also part of state territory under international law, right? Which is above the land and also which is above the national internal waters and also territorial sea. I will further elaborate on this later. On state jurisdiction, if a person, right, commits an offense in Malaysia, right, for example, and he runs away or escapes to another country, such as to Indonesia. Now, the question here is that whether Malaysian authorities may exercise jurisdiction, right, or may go onto the territory of Indonesia, arrest that individual and bring him or her back to Malaysia to face criminal prosecution, right? So in this situation, the Malaysian courts may have jurisdiction to try the offender, right? But the Malaysian police cannot enter Indonesian territory and arrest him and bring him back to Malaysia. I will share with you some of the examples. So if Malaysian authorities went to Indonesia or went onto Indonesia or go to the Indonesian territory and arrest the perpetrator or the criminals or the offender, so this will contrary or violate the well-established rule of international law on impermanent non-habitat burial, right? Because it violates state sovereignty, right? Because Malaysian authorities cannot go onto Indonesian territory and arrest the offender and bring the offender back to this country. Right? So persons may not be arrested, police investigations may not be mounted, and summonses may not be served on the territory of another state, right? Like in the case or in the example that I've given you. So the law of Malaysia, the police teams of Malaysia cannot go to Indonesia and arrest the offender except with the consent of that state, i.e. Indonesia, or under the terms of a treaty, i.e. on bilateral treaty such as extradition, right? Even we have extradition, a bilateral treaty with Indonesia, for instance, that only the authorities of Indonesia may arrest the wanted criminals and then to be surrendered and also to be extradited to Malaysia. Now, I would like to give you an example, right, where in the case of the North Korea, Malaysia, US case, right? The case of Moon Chol-myong against Minister of Home Affairs and others, which was decided by the High Court in 2020. Now, what happened in this case was Mr. Moon Chol-myong, he is a North Korean citizen, right? So he committed a crime while he was in the US, right? So he is a Korean citizen, was in the US, he committed an offense or offenses in the US, which related to narcotic drugs, i.e. On money laundering and also conspiracy crimes, right? And he was to be charged under the US Racketeer Influence and Corrupt Organizations Act, or RICO. So he went to Malaysia, he ran away from the US and was hiding in Malaysia, right? So when he was hiding in Malaysia, the US requested Malaysian authorities to arrest Mr. Moon Chol-myong and to be extradited and to be surrendered to the US, right? So while he was hiding in Malaysia, basically Malaysia and the US, have extradition bilateral treaty since 1995. right? So this, and also Malaysia has extradition ordinance 1958, right? So we have extradition bilateral treaty with the US, which is still in force even until now. So when Moon Chol-myong was in Malaysia, so the US requested Malaysia to extradite him to the US to stand trials for the crimes, right? So this Korean citizen was arrested by the Malaysian authorities, right? So he contested on the arrest because he argued that he cannot be arrested and cannot be surrendered to the US because the crime was never committed in Malaysia, right? So the Malaysian High Court held that he should be extradited to the US as requested by the US authorities, right? On the grounds that, number one, Malaysia has extradition bilateral treaty, right, since 1995, and Malaysia has the extradition ordinance 1958, which enforced the extradition bilateral treaty with the US. So that is, even though the crime was committed or were committed in the US, since the existence of extradition bilateral treaty between Malaysia and the US, as such, Malaysia has to extradite this Korean citizen to the US to stand trials for the crimes. Now, another example is in the case of Eichmann, right? Between the Attorney General against Adolf Eichmann, which was decided after the end of Second World War by the District Court of Jerusalem, Israel. Now, what happened in this case was, right, Mr. Adolf Eichmann, he was a Nazi officer who was responsible for the war crimes and also crimes against humanity committed against the Jewish people during the Second World War. So he, during the Second World War, right, during the Nazi occupation, so he oversaw the transport and also the deportation of Jewish people, right? And also he set up and personally ran an operation center in Hungary in order to implement the final solution to exterminate the Jewish people at that time, right? So, and also he organized and transferred money from evacuated Jews to the state and was responsible for the administration of the camps at Terezin and Bergen-Belsen. So, at the end of the Second World War, right, he ran away and also was hiding in Argentina, right? So when the state of the Jewish state or the Israel, the state of Israel was established, so Adolf Eichmann was and became a wanted person, right, in order to face criminal trials for the alleged war crimes and also crimes against humanity in Israel. Right? So when he was hiding in Argentina, he was abducted, right? He was kidnapped by the Israeli intelligence service known as Mossad. And when he was abducted in Argentina, so he was to be brought back to Israel to stand trials before the District Court of Jerusalem, Israel. Right? So he contested the jurisdiction of the District Court of Jerusalem in Israel, right, on a number of issues. So among the issues are, number one, whether the District Court of Jerusalem has jurisdiction to try the case, right, because Eichmann is a foreign national. He's a German, right, and the crimes were committed on foreign territory, i.e. Hungary. And secondly, whether the jurisdiction negated by the abduction of the accused from a foreign country, i.e. From Argentina, and to be brought back to Israel, to Israel to stand trials. So the District Court of Jerusalem held that the court has jurisdiction, right, for the alleged crimes, because those crimes, i.e. the war crimes and also crime against humanity, are considered as international crimes. And at that time, there was no international court ever established. So the District Court of Jerusalem was to exercise universal jurisdiction against Adolf Eichmann. So I will further elaborate on universal jurisdiction. So the reason why the District Court of Jerusalem at that time contended that it has jurisdiction under the purview of universal jurisdiction, number one is because the crimes committed by Eichmann were international crimes. Number two, the victims were Jewish, right, which linked to the state of the Jews, i.e. Israel, right, and is also vital to the state, right, in accordance with a protective principle jurisdiction, which I will also further elaborate in the later slides. Right? So when the case was decided by the District Court of Jerusalem, again, Eichmann contested on the decision, and the case was appealed up to the Israeli Supreme Court. However, the Supreme Court of Israel upheld the decision of the District Court of Jerusalem. Right? Even until today, you know, the decisions of these two courts in Israel receive many criticisms. So if you have any question on this, and you may write down your questions at the chat box, or you may ask. Now, state jurisdiction, having finished with state jurisdiction, so we'll go to courts or tribunals jurisdiction. Now, when we talk about when we talk about courts or tribunals jurisdiction, it relates to a number of important elements. Number one is the right of the court or the right of the tribunal to adjudicate cases, right? To hear the cases and also to make judgments over the case. And number two is the scope and limit of the court's jurisdiction, right? Whether it is civil cases, whether it is civil case, or criminal case, or appellate jurisdiction, advisory jurisdiction, and so on, depending on the jurisdiction of the court. So the right scope and limit of the courts or tribunals jurisdiction, right, which I will explain for the purpose of today's lecture, is to be explained based on the jurisdiction of international courts and tribunals such as the ICJ and also the ICC. Right. So now the same goes to the case of Eichmann just now, where the state, the District Court of Jerusalem in Israel decided to exercise jurisdiction over the case of Eichmann just now. So I don't want to repeat myself. So that is one of the examples on how national courts, especially, you know, derive and also to exercise this jurisdiction, right, on a number of principles under international law. Right? I will further elaborate on those principles, such as on the universal jurisdiction and also protective jurisdiction. Right? Now, civil and criminal jurisdiction. Now, where the rules of international law, right, on general principles of jurisdiction governing the exercise of jurisdiction by states vary according to whether the jurisdiction is civil or criminal, right? There are two opinions on this, right? Number one, there is no distinction between civil or criminal jurisdiction, right? So the rules of international law will be applicable. So what are those rules? I will further elaborate. Right? So according to some authors or some scholars, where they argued that now there is no distinction between civil and criminal jurisdiction because the rules of international law governing jurisdiction in criminal cases and those of civil cases are similar, right? But there are some other writers, which are the majority of international law scholars, were of the opinion that rules of international law governing jurisdiction in criminal cases are different from those in civil cases. Now, why the general principles of jurisdiction of civil and criminal jurisdiction are different in nature, right? For example, on the principle of universality principle or universal jurisdiction, and also trial in absentia. Because for civil jurisdiction, for instance, that state may apply various principles, such as the presence of the defendant, right? And also the presence of the assets or the defendant, the nationality of the defendant, for instance, and also the domicile or residence of the defendant, right? So all these normally will not be applied in criminal cases, right? Because some criminal jurisdictions, trial in absentia is allowed, right? Because it has been inserted under a number of international tribunals statutes, right? Before we have the International Criminal Court at the moment. Now, the general principles on criminal jurisdiction under international law. Basically, there are 5, right, of general principles of criminal jurisdiction under international law. Number 1 is territorial principle. Number 2, nationality principle. 3, protective principle. 4, passive personality principle. And first, we will look at the territorial principle. This territorial principle is commonly and mostly used, right, under international law, whereby jurisdiction, right, of the court and also of the state will be based on territorial principle, right, which determine based on or by reference to the place where the offense was committed, right? So a state can exercise jurisdiction over persons, property, acts, events took place within its territory. Now the question is, what is state territory? Right, under international law, state, right, the territory, the land territory of a state. Number 2 is the airspace. 3 is territorial sea, which I have explained to you earlier, 12 nautical miles from the coastline, right? This is still considered as state territory. 4th is registered ship, right? This is also part of state territory, where a ship which flies a flag of a state, if any crimes committed on board of that particular ship, still it will be considered as if the crime was committed on the land of the state, right? On which the flag of the territory of the state has been flagged, right? And lastly, the registered flag, right? The same with ship. So whatever citizenship of the flight, right, will be considered as the territory of that particular state. Right? We have to look at the nationality of the ship and also the nationality of the flight or of the plane. Now, the illustration, right? I will just give you briefly of the illustration. So, for example, that when John has violated or committed a crime in the state of Covida and has been arrested on the territory of the state of Covida, right? Covida, right? So he committed a crime on the territory of the state of Covida, arrested on the same territory, right? So this is commonly used, right? Why? Because of the certain advantages. Number 1, the territorial principle to be applied is due to the forum convenience, i.e., where it involves the interest of that state, right? Because the crime was committed on that particular territory, right, where the crime took place, and also the availability of the witnesses, and also the evidence, right, likely to be found on that particular territory. So that is why territorial principle will be applied, right, because of the crimes committed, right? Now, for a territorial principle, there are 2 types. Number 1 is subjective, and number 2 is objective. Right? So, subjective territorial principle means that a state has jurisdiction over conduct or offense where or if it commences within its territory but is completed abroad, right? So let's say the crime commences within its territory, but it is completed abroad, right? still the court where the crime was first commenced will exercise jurisdiction, right? For example, John breaches the law of the state of Covida. His conduct has commenced in the state of Covida, right? But completed in the state of Coronia, right? So normally both states, either state Covida or state Coronia, will contest on the jurisdiction, right? The state of Covida will argue that the commencement of the crimes took place within its territory, but the state of Coronia will argue as well that the end result has been completed on its territory. So both will be having jurisdiction. So that will be the subjective jurisdiction under international law of territorial pursuit. So a state has also jurisdiction over conduct or offense if it commences outside its territory but is completed in its territory, right? So the same with the jurisdiction or with the example which I have given to you just now, right? So if the crime commenced in the state within the territory of state A, but it is completed on the territory of state B, right? So these will be contested, all right, by both countries, right? So the objective test will be applied, right? For instance, John fires a gun across the frontier of state Covida and caused death on the neighboring state Covida, right? On the neighboring country, right? So which country will exercise jurisdiction, right? So all these will be argued by both parties or both states on the exercise of jurisdiction. So I would like to give an example or an illustration on both objective and subjective territorial principle or territorial principle of criminal jurisdiction, right? Such as in the case of Lockerbie, right? In the case concerning questions of interpretation and application of the 1971 Montreal Convention arising from the Errol incident at Lockerbie, between Libyan Arab Jamahiriya and the United States of America in 1998, which was decided by the International Court of Justice. Now, what happened in this case was a flight of Pan American World Airways, or known as Pan Am, right? So the United States is a registered state for Pan Am, right? Is a regularly flight schedule from Frankfurt, Germany. So there was a typo there. Germany to Detroit, the US, right? Via London and New York. So what happened was, it was destroyed by a bomb, right? Which killed 243 passengers and 16 crews, right? So when the plane was destroyed, the aircraft crashed onto residential areas of Lockerbie, Scotland, killing 11 people on the ground, right? So 11 Scottish people, British citizens, that were killed because of the plane crash, right? Due to the bombing, right? So now, number one, the US is the registered flight, right? And the flight, right, was from Germany, right, and was on its route to the US, right? But it uses the route from London, right, to New York. So the bomb exploded and the plane crashed on the territory of the UK, on Scotland. So there are a number of states which are interested to exercise jurisdiction over the case. Number one is the US, because according to the US, the crime or the bombing was committed on its territory, right? Because the plane Pan Am was the US registered, right? Then as such, the US claimed jurisdiction over the bombing. Germany also claimed jurisdiction because Germany argued that the commencement of the bombing started in Germany, right? Scotland and the UK also claim jurisdiction because the plane crashed on its territory and killed 11 of its citizens. So 3 states, claim jurisdiction over the crime, right, or over the perpetrator. And the case was brought to the ICJ, right, to decide whether which states out of the 3 to exercise jurisdiction over the bombing and over the matter, right, against the perpetrators. So the ICJ held that, right, practical reason for asserting jurisdiction should be given to Scotland, right, to the UK, right? Why? Because of the existence and also the availability of physical evidence existed within the jurisdiction of Scotland, United Kingdom, right? Even the US is the registered flight, and the crime commenced in Germany, but due to the availability of physical evidence existed on the territory of Scotland, the United Kingdom, then Scotland, UK will have the jurisdiction. Right? So the Harvard Research Draft Convention was drafted. So under the Harvard Research Draft Convention, it states that a state is to be allowed to exercise territorial jurisdiction when a crime is committed in whole or in part within its territory, right? So based on the decision of the ICJ in Lockerbie case, so international law has been expanded, right? So it does not only apply to whether the crime was wholly committed on its territory, but even partly committed on the territory of that particular state, that state may exercise its territorial jurisdiction under international law based on the case of Lockerbie just now. The second principle on criminal jurisdiction under international law is nationality principle. Now, state may exercise jurisdiction, right, over natural or juridical persons, i.e., the alleged perpetrator must be a national of a state. It cannot be stateless, right? So it must be a national of a state, and also or a company or a ship or a plane, right, that have nationality, right, for the crimes committed by them on board, right? Either on board or either on the territory, right? So the jurisdiction will be exercised only when the natural or juridical person or the perpetrator of the crime comes within its jurisdiction. So again, it goes back to the territorial principle, right? Although nationality principle will be applied, but it goes back to the general application, the territorial principle, right? For instance, John, a national of a state of Covida, breaches the law of the state of Covida. His conduct may commence or end anywhere abroad. The state Covida may only exercise jurisdiction if John is to be found within its territory, right? So it may exercise jurisdiction against against its national, right? The national of Covida, right? But the perpetrator must be found within its territory first before the perpetrator to be charged for whatever crimes. The third principle under international law is protective principle. Now, a state can exercise jurisdiction over foreigner for acts committed abroad or outside its territory if such acts prejudicial to state security, integrity, or national interests, right? So let's say crime was committed or to be committed outside territory. So before the effect of the crime hits the country or affects country A, for instance. So country A may exercise jurisdiction on the basis of protective principle in order to protect its security, its integrity or its national interest. Right? For instance, John, a national of state of Florida, commits a crime, right, which prejudicial to state of colonial security. So his conduct may commence and end anywhere in the world, right? So in this case, the state of Coronia may exercise jurisdiction against John in order to protect its security. However, this type of jurisdiction is very to be debated and has a number of issues, right? Because how state measures whether the act or the effects of the crimes will affect its security or its integrity or its national interest, right? So state may argue based on certain officials or intelligence, for instance, but the issue of whether the intelligence gives the state an authority or a green light to exercise jurisdiction over a foreigner which has committed a crime abroad, right? Because the crime has yet to affect its territory, right? Or has yet to affect its nationals. But state take action in order to prevent and also in order to protect its national interest. So this is most controversial jurisdiction under international law. Fourthly is passive personality principle under international law. Now, a state may exercise jurisdiction over foreigners for acts committed outside territory if the victim of the act is a national of that state, right? So let's say the national of state A is abroad, right, in state B or state C, then a crime has been committed on state B or state C, which the victim of that crime was the national of state A, right? Then state A may exercise jurisdiction, right, on passive personality principle. But all in all, the perpetrator of the crime must be present on the territory of state A in order for state A to exercise jurisdiction, right? So again, it goes back to the territorial principle, because the perpetrator must be found within its territory first before the perpetrator can be charged for any criminal offense, right? With an exception if there is an existence of bilateral extradition treaty between state A and state B or state C, so that the perpetrator of the crime can be arrested and can be surrendered to state A for criminal prosecution. There is a case decided in 1887 on passive personality principle, known as the Cutting case. So I would like to briefly explain this case. So what happened was, there was an American citizen who was charged before a Mexican court for publishing a defamatory statement against against a Mexican citizen in Texas newspaper, right? So an American citizen was charged before a Mexican court for publishing defamatory statement against American citizen in the Texas newspaper. So it was held that a court in Mexico assumed to have a criminal jurisdiction based on passive personality over an American citizen for defamatory statement made against Mexican citizens, right? So because it affects, or because the defamatory statement made by this American citizen affects the Mexican citizen. So the court in this case assumed jurisdiction under passive personality principle, right? Again, this kind of jurisdiction is also controversial, because in order for the court, right, to exercise jurisdiction over a foreigner, that accused person must be present within its territory. So like in this case, the Mexican authority cannot go to onto any American soil or American territory and arrest that American citizen who made defamatory statement, bring him back to Mexico and to stand trial. So, as with the case of Eichmann earlier, right? So this is cannot be applicable, right? So and it is very controversial under international law. And lastly, on the principle of universal jurisdiction, or known as universality principle. Universality principle or universal jurisdiction is commonly based on the nature of the crime, right? So some crimes, right, under international law is considered as universal crime, right? Because some crimes under international law have been considered as hostis humani generi, or enemies of all mankind, and also delicta iure gentium, or international crimes. So these two crimes, hostis humani generi or delicta iure gentium, are considered as jus cogent crimes under international law. Now, jus cogent crimes basically have the elements which are so destructive to international order and contrary to interests of international community. So if jus cogent crimes have been committed, any state in the world may exercise jurisdiction over the perpetrators, right? But with certain limitations. I will further elaborate on the limitations later on. Now, what are the jus cogent crimes? What are the hostis humani generi, and also what are the delicta iure gentium crimes, which are considered as jus cogent crimes? They are normally 7 crimes, right, under international law. Number 1 is genocide. Number 2 is crimes against humanity. Thirdly, war crimes. 4th, piracy. 5th, slavery and slave-related practices. 6th, torture, and also lastly, the prohibition of the use of armed force or the crime of aggression. So all these 7 crimes are considered as jus cogent crimes. So if any of the crimes out of these 7 has been committed, right? So the perpetrator may be charged and may face criminal trials. So any state in the world may exercise jurisdiction over the perpetrator under the purview of universality principle or universal jurisdiction. However, this principle, universality principle, has limitations. I will explain that now. So coming back to the 5 principles that I have mentioned to you earlier, that regardless of territorial principle, nationality principle, protective principle, passive personality, or universality principle, the perpetrator or the accused person or the wanted person or individual criminal usually, right, must be present, right? So there was typo here, within its territory, right, in order for the court to exercise jurisdiction. Now, there is an issue under international law whether trial in absentia is allowed under international law, right? Can someone or the accused person not be present in the court and he or she can be charged before a court of law, right? So this is known as trial in absentia. So under international law, it is prohibited after the came into force of the International Convention on the Civil and Political Rights, for ICCPR 1966. Because under Article 14, Clause 1 of the ICCPR, it states that, and I quote, all persons shall be equal before the courts and tribunals in the determination of any criminal charge against him or his rights and obligations in a suit at law. Everyone shall be entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law. That's number 1. Principle number 2, enshrined under ICCPR, is under Clause 3 of Article 14, where it states that, and I quote, that person to be tried in his presence and to defend himself in person or through legal assistance of his own choosing, so and so. So as such, after the came into force of the ICCPR, then trial in absentia is no longer applicable under international law. So as such, the accused person must be present before the court of law, and he or she must be given the chance to defend himself or herself, right, through legal assistance or through his or her own lawyer, right? So that is the issue of jurisdiction and international law. Now, on the point of universality principle earlier, which I have explained to all of you, particularly on jus cogens crimes, even though all states in the world may exercise jurisdiction over the perpetrator, however, there is an exception to that particular principle under international law, right? So the one of the exceptions is on the immunity under international law, accorded under customary international law. Now, under international law, before the outbreak of the First World War, so the ruler, right, or the head of state and state itself were considered as one. If you are talking about state, or if we are talking about the head of state, right, ketua negara, right, the president or the king or the queen. So these two are considered as one and must be treated alike, right? And the ruler or the head of state and also state must enjoy and shall enjoy absolute immunity, or known as sovereign immunity, right? So head of state cannot be charged in any court of law on whatever crimes, right? Because under international law, again, I would like to go back to the principle of par imparem non habet imperium, right? Because the absolute immunity or sovereign immunity lies within the principle of par imparem non habet imperium, because an equal has no power over an equal. One state cannot prosecute or charge another state, because the head of state is considered as the state itself. So the head of state cannot be prosecuted before the court of another state, right? So that is why before the First World War took place, so the head of state or the sovereign and also the state, they are all treated alike, right? So it reflects the principle of sovereignty of states and subjecting states to a foreign court's jurisdiction amounting to a violation of the principle of state sovereignty or state, the equality of a state under international law. So this immunity is considered as customary international law. So it must be applied and it binds all states in the world. Now, however, after the end of the First and the Second World War, so this sovereign immunity or absolute immunity is no longer applicable, right? So because many rulers, after the outbreak of First World War and Second World War, many rulers or the head of states have been using their immunity to prevent themselves from being prosecuted before any courts for committing international crimes, right? Remember, the jus cogens crimes, number one is the crime of aggression, the use of force, right? So First World War and Second World War is all about using force against another state's territory. And many crimes have been committed, particularly on crime against humanity and war crimes at the time, right? So that is why immunity, sovereign immunity or absolute immunity is no longer applicable after the First World War. Because a number of heads of state have been prosecuted for the crime. So I will show you some examples there. Still, even though absolute immunity is no longer applicable, but customary international law provides the head of state with two types of immunity, right? So still the head of state will enjoy and shall enjoy immunity, right? So there will be two types. Number one, known as immunity ratione personae, or known as personal or private immunity. Secondly, immunity ratione materiae, or known as official immunity, right? So ratione personae means personal immunity. So rationale materiae is official immunity. Now, so this immunity rationale personae and rationale materiae of customary international law was crystallized and codified into the Vienna Convention on Diplomatic Relations 1961, or known as VCDR. So this convention, or the VCDR, has been ratified and acceded by almost all countries in the world. So at the moment, there are 192 out of 193 states which are parties to the VCDR. Right? So under the VCDR, particularly under Articles 29 and 31, so they mention that the diplomats, right? So because the VCDR are normally to be applied to diplomats, right? So it states these two provisions mention that the diplomats, including their staffs as well as their family members, shall be inviolable, and they cannot and shall not be subject to any arrest whatsoever, enjoy an absolute immunity from criminal prosecution. Right? So who knows that in the future that some of you might become ambassadors to many countries in the world, then the VCDR will be applicable to all of you. Right? So now, the inviolability of the diplomats, right, have been upheld by the ICJ in two cases. Number one is in the arrest warrant case between the Democratic Republic of Congo and Belgium in 2002, and also in the case of mutual legal assistance in criminal matters between Djibouti and France in 2008. Now, these two ICJ cases mention that, now remember, the VCD are only applicable to diplomats. But the ICJ in these two cases extended the application of the VCDR not only to be applicable to the diplomats as well as their staffs and family members. So this VCDR shall also be applicable and to be extended to state high-ranking officials. Right? So from these two decisions of the ICJ. Now, who are these state high-ranking officials? Under international law, state high-ranking officials are number one, the head of state, ketua negara. Tak kira lah, regardless whether that head of state is the king, the queen, or the president, as long as he or she is the head of that sovereign state. Number two, the head of government, right? Ketua kerajaan, the prime minister. And lastly, the minister of foreign affairs. So these three individuals are known as heads of state, right? And also these three are considered as, or to be called as the troika. The troika is called the three, means that the heads of state. Now, under Article 32 of the VCDR, again, it states that their immunities are temporal, right? The immunity attached to the diplomats and also to the heads of state are only to be applied temporarily, right? So within certain time only, right? It cannot be applied for the rest of their life, right? Because this immunity belongs to the state, right? And it can be waived by the state at any time. Now, under Article 32 on temporal immunity, right, is to be given to immunity rationale personae. Now, this immunity rationale personae applies to the sitting head of state only. What does it mean? It means that if the three, the troika just now, the head of state, president, or the prime minister, or the Minister of Foreign Affairs, they will enjoy absolute immunity or immunity rationale personae as long as the troika, this troika, the head of state, are still in the office. they still hold office as the head of state, as the prime minister or the head of government, or as the foreign minister, right? Now, this immunity is absolute. Even the Troika has committed use cogent crimes, right? War crimes or genocide, the Troika cannot be prosecuted. He or she shall enjoy absolute immunity as long as he or she is still in the office, right? Let's say a president of a country holds office for 5 years term. So within this 5 years term, he or she shall have absolute immunity, even if he or she has committed use cogent crimes. So any courts in the world cannot exercise jurisdiction. Any courts in any state cannot exercise jurisdiction, especially on universal jurisdiction, right? Because the Troika is considered as the state. Right? So under international law, if the Troika is considered as the state, then par imparem non habet imperem will be applied, right? So once the reasonable period of time comes to an end, after the expiry of the term, right? Let's say the 5 years term has come to an end, right? Or he or she leaves the receiving state, right? Let's say that the president or the prime minister or the foreign minister of A travels abroad and goes to state B. When he or she is still in state B, he or she shall have absolute immunity under immunity rationale personnel, right? So if after the expiry of the tenure of the premiership or as the foreign minister, right? Or when she leaves or he leaves the state, right? He is no longer protected under immunity rationale personnel, right? But even after the expiry of immunity rationale personnel, upon the expiry of the term of the office, still international law accords the Troika with immunity rationale material. So immunity rationale material will take over. However, this immunity rationale material will not be applicable in all situations, but only limited to all official acts which or conducts performed by the Troika or by the diplomats earlier, while he or she being the sitting head of state. Okay. So upon the expiry of the tenure, immunity rationale material will take over. But this immunity rationale material will only be applied to the Troika only for all official acts performed by the Troika when he or she was the head of state, right? During the office. Now, this has been held by the ICJ again in the case of diplomatic and consular staff case between United States of America and Iran, right? Where the ICJ, I quote, and I quote here, states are bound to protect the inviolability and immunity of the head of state as long as he or she has acted or performed official acts while being in the office, right? So whatever decisions made by the head of state, right, during the tenure, during the office, right, within his official capacity, the heads of state cannot be charged for any crimes, right? So if the heads of state have exceeded his or her official acts, right, or official conducts, then he or she may face criminal charges under international law. Now, what constitutes official acts or conducts of the heads of state? So this determination on whether the acts, right, or the conducts done by the heads of state during the tenure is considered as official act or not must be determined by case by case basis, right? So I would like to highlight one of the cases here, such as in the case of Augustus Pinochet. Now, what happened in this case was Augusto Pinochet was an army general and also the president of Chile, right? So remember, he was the president of Chile, and as such, he is the head of state. So under international law, he has immunity, right? So he ruled Chile dictatorship between 1973 until 1990, and he was allegedly to have committed torture, crimes. So when after the tenure, right? When he longer became the president of Chile, right? So on October 1998, the Spanish court issued an international arrest warrant against him under the purview of universal jurisdiction. Remember, torture is one of the international crimes, and universal jurisdiction may be invoked by any states in the world. So it's the Spain, through its court, issued an international arrest warrant against Augustus Pinochet, right? After he seized office as the president, now he is no longer now, after he seized office as the president, so he went to London, right, the UK, for medical treatment, right, because he has he had this heart problem. So he went to the UK for medical treatment. So when he arrived in London, he was arrested, right, by the UK authorities. So he argued that he has immunity under international law, right, being the former Chilean president, right? Even as the former head of state. So he argued that he has immunity rationale materiae, right? So he filed a case to contest on his arrest before the courts in the UK, and even up to the UK House of Lords. So the UK House of Lords held that the head of state, right, in this case, General Pinochet, will not be protected under immunity rationale materiae because torture is an international crime, number one. And number two, the act of committing torture is outside his official duty as the president of Chile. So as such, he cannot be protected under immunity rationale materiae, and as such, he must be arrested and must be surrendered to Spain to face criminal charges for committing torture as an international crime. However, he died on 10 December 2006 without having been convicted, right, by the Spanish court. Now, another case before the international courts or tribunals, in the case of arrest warrant, or the case concerning the arrest warrant of 11 April 2000 between the Democratic Republic of Congo against Belgium, decided by the ICJ in the year of 2002. Now, what happened in this case was the court in Belgium issued an international arrest warrant against His Excellency Abdoulaye Yerodia Ndombossi under universal jurisdiction for allegedly to have committed genocide in the DRC, the Democratic Republic of Congo, right? So at that time, when an international arrest warrant has been issued by the Belgian court against Yerodia, right? He was the sitting Minister of Foreign Affairs, right, at that time, right? He is still the sitting head of state, right, of the DRC, right? So the issue, the arrest warrant was issued by the Belgium court, and he he was to be arrested, right, for genocide. Now, the DRC challenged this international arrest warrant issued by Belgium against His Excellency Yerodia before the International Court of Justice, because according to the DRC, Yerodia has immunity under international law because at that time he was still the sitting head of state of the DRC as the foreign minister. Even he was alleged to have committed or incited genocide in the DRC. So the ICJ decided in this case in his favor. The ICJ held that the sitting head of state shall be inviolable because this is customary international law. Not only customary international law, it has been enshrined under Article 32 of the VCDR just now. So state must uphold the inviolability of the sitting heads of state, i.e. under immunity rationale personnel. But the court, when deciding this case, the court mentioned that there will only 4 exceptions where the sitting head of state can face criminal prosecutions. So what are the exceptions? Number 1, the ICJ decided that the Troika shall not be protected under immunity rationale personnel if he is to be tried or if she is to be tried before his or her own domestic court in accordance with the relevant rules of domestic law. For instance, in the case of Yerodia, only the court in the DRC can exercise jurisdiction against him, right? This is exception number 1. Exception number 2 is that if the state waives the head of state's immunity, right? For example, in this case, in the case of Yerodia, if the DRC decided to take back or to waive immunity accorded to Yerodia, because immunity rationale personnel is procedural in nature. It can be waived by state at any time. So if the DRC decided to take back or to remove immunity accorded to Yerodia, then only then Yerodia can be arrested and can be surrendered to Belgium and to face criminal prosecution. Thirdly, if the head of state ceases his or her office, right, when the term of the heads of state has come to an end, right, then he or she can no longer be protected under immunity. Remember, international crimes, cannot bar any criminal prosecution against former heads of state, like in the case of Pinochet just now, right? Because committing international crimes is not within the official acts. And lastly, if the head of state or if the sitting heads of state is to be tried before competent international courts. Now, remember, just now, in the case of Yerodia, Belgium would like to exercise jurisdiction. So the DRC and Belgium, these 2 states are equal in the eyes of international law under the principle of par imperium non habet imperium. So one state is not superior than another state, right? So according to the decision of the ICJ, in this case, only a tribunal or a court which is established, right, to have jurisdiction at the international level may exercise jurisdiction over the sitting heads of state, because international courts will be superior than state itself and will be above the state, right? So only within these 4 exceptions where sitting heads of state can be charged for committing international crimes. If the sitting heads of state committed international crimes and do not fall within any of these 4 exceptions, then he or she shall enjoy absolute immunity under international law. So the prosecution of heads of state, especially before international courts, is not new. right? But have been tried before various international courts, such as by the Turkish military tribunal established after the end of the First World War, the trials before the courts in Leipzig, Germany, also after the end of First World War, the International Military Tribunal at Nuremberg, right, established in Nuremberg to try the Nazis, German, for the commission of the Second World War. The International Military Tribunal for the Far East, established in Tokyo, and the International Criminal Tribunal for the former Yugoslavia in 1993, and also the International Criminal Tribunal for Rwanda, or ICTR, in 1994. Now, these are the examples where the heads of states have been prosecuted before these various international tribunals, right? Such as the Turkish military tribunal, where the prime minister and also a number of ministers of the Ottoman Empire have been prosecuted, and also the trials before the court in Leipzig, Germany, where the then German head of state, Emperor William II, was supposed to be prosecuted, but at the end he ran away and took refuge in the Netherlands. But as such, he cannot be prosecuted. Remember that one state cannot go, an individual cannot be arrested on the territory of another state, right? Because on the principle of state sovereignty. So that is why when German head of state William Emperor II ran away and take refuge in Netherlands, then it was a safe haven for him, because he cannot be arrested, because the Netherlands refused to arrest him and to surrender him to be prosecuted before the court in Germany at that time. But other German leaders have been prosecuted in lieu of William II. So before the International Military Tribunal, or the IMT, various state leaders have been prosecuted, such as Adolf Hitler before he committed suicide. So he was supposed to be prosecuted for committing war crimes and crime against humanity, as well as the crime of aggression, but he committed suicide. So later on, Admiral Dönitz took over the administration, and he was prosecuted by the IMT together with other German leaders at that time. So the International Military Tribunal for the Far East also, the Emperor Hirohito was also supposed to be prosecuted, but General MacArthur at that time decided not to prosecute him, because at that time, it will create chaos in Japan if Emperor Hirohito was to be prosecuted. So as such, other leaders such as Prime Minister Togo and so on have been prosecuted in lieu of Emperor Hirohito. Before the International Criminal Tribunal for the former Yugoslavia, 2 presidents of the former Yugoslavia have been arrested, surrendered, and charged before the ICTY, such as President Slobodan Milosevic and also President Milan Milutinovic. Before the International Criminal Tribunal for Rwanda, Prime Minister Sean Kambanda was arrested and was charged before the ICTR and was found guilty by the ICTR for genocide and sentenced accordingly. We also have a number of hybrid tribunals established, right, with the agreement made between the Security Council and the government concerned, such as the government of Sierra Leone and also the Cambodian government, where the special court in Sierra Leone in 2000 was established, and also the extraordinary chamber in the courts of Cambodia, or the ECC, was established in 2004 in Cambodia in order to prosecute the perpetrators of international crimes, where President Charles Taylor of Liberia was charged and found guilty by the special court in Sierra Leone for war crimes and crime against humanity, and also Khieu Samphan the then president of Cambodia was sentenced by the extraordinary chamber in the courts of Cambodia for committing genocide and crime against humanity, right, during the Khmer Rouge between 1974 until 1979. The same goes to the ad hoc tribunal in Timor-Leste or East Timor. Now, those tribunals that we have seen earlier, those tribunals have been established temporarily or ad hoc in nature. Now we have the Permanent International Court, known as the International Criminal Court or the ICC, located at The Hague in the Netherlands. So the ICC basically has 4 jurisdictions of international crimes. Under Article 6, the court has jurisdiction on genocide. Article 7 on crime against humanity. Article 8 on war crimes, and Article 8 based on the crime of aggression. So there are a number of heads of state have been charged before the ICC and have been found guilty by the court, right? Even though they are still the sitting heads of state at the time, because according to the decisions of the decision of the ICJ in the case of Eurodia just now, only an international court with competent jurisdiction may exercise jurisdiction against the sitting heads of state, right? So as such, a number of sitting heads of states have been prosecuted and challenged before the ICC. Number 1 is President Omar al-Bashir of Sudan. Number 2, President Muammar Gaddafi of Libya. Number 3 is President Laurent Gbagbo of Cote d'Ivoire, and lastly, President Uhuru Kenyatta of Kenya. So these 4 presidents or heads of state of their respective countries have been charged and prosecuted before the ICC. However, for President Muammar Gaddafi, he died in the prison, and as such, his sentence was omitted by the ICC. Now, how about the Southeast Asian countries? Because as we all know that there are various types of heads of state in Southeast Asia, right? Because in Southeast Asia, we have 11 countries or 11 states. So there are various head of state in Southeast Asia, such as for Brunei Darussalam. Brunei has His Majesty the King of Brunei as the absolute monarch. Right, for Brunei. For Malaysia, we have His Majesty the Yang di-Pertuan Agong as the King of Malaysia. And for Thailand, we have the King of Thailand. For Cambodia is His Majesty the King of Cambodia. And for Indonesia, the head of state is the President of Indonesia, His Excellency President Joko Widodo. For Singapore, Singapore has its own president as the head of state, President Her Excellency the President of Singapore. For Vietnam also, and also for Myanmar and the Philippines, these are all the presidents of their respective countries, as well as Laos and Timor-Leste, right? So if you look at the constitution of these various countries, the position of the head of state varies from one state to another, because for Brunei, it is an absolute monarchy system. For Malaysia and Thailand, as well as Cambodia, it is constitutional monarchy, while Indonesia is the president in the presidential system, and same goes to the Philippines. But other countries in Southeast Asia, you know, the prime minister has more power than the president under the also under the presidential leadership, right? But you know, we must look at case by case basis, looking at how the structure of the head of state or the structure of the leadership has been enshrined under their respective constitution. Right? So with that, I thank you, and I open to any Q&A if any of you have anything to ask. That's all from me. Thank you so much.
Thank you, Dr. Farid, for that impactful sharing. Now we open the floor for Q&A session. So if you have any question, you may leave them in the chat box and we can ask them for you. Don't forget to state your name and of course the question, or you may yourself unmute your microphone, introduce yourself and proceed with your question. Well, I see we have received a few questions in the chat box. Allow me to read it for you. From Miss Siti Aisyah Maisara. Doctor, let's say A, who had committed a crime in his original state, and let's say the punishment was a mandatory death. A flew to state B and he then was given an asylum. Later, he conducted a murder crime while in state B. So for the second crime, can state A has jurisdiction to try him, and can a person in asylum or protected be charged for his later crime?
Now, in this situation, both countries A and B will have jurisdiction because crimes have been committed on both territories of state A and state B. Right? But the issue here is that on which territory that the alleged perpetrator or the criminal has been found. So only then the state which has the perpetrator within its territory may exercise jurisdiction. If the perpetrator has been found on the territory of state B, and crimes have been committed on the territory of state B, then state B may exercise jurisdiction, right? So, however, in this situation, state A may request state B to surrender the perpetrator to state A to face criminal charge, right? But this can only be done if state A and state B has bilateral extradition treaty. If there is no extradition treaty between the two states, then state A cannot request state B to arrest and surrender the perpetrator and to be surrendered to state A. So in this situation, in the absence of bilateral extradition treaty between the two states, then state B may exercise jurisdiction if the perpetrator has been found on its territory and if the crime was committed on state A. Hope I have answered the question.
Thank you, Dr. Farid. Hope that answered your queries, Ms. Aisha. Now to the next question from Mr. Abdul Hakim. Doctor, can a national court make an order to prevent crime which affects other state territories with the purpose to protect its country and other countries' interests? And what is the legal implication if the state ignore the binding multilateral treaty which requires the party to obtain permission from affected state before proceed with the order from national court?
Now, this is a very controversial application of jurisdiction under international law, protective jurisdiction. Because like in the case of Nicaragua, if you read the case, Nicaragua, between the US and also Nicaragua, which was decided by the ICJ, the US claimed jurisdiction over the Nicaraguan citizen for the crimes allegedly to be committed outside the US, but the impact of the crime might have affected the interests of the US. So the US would like to exercise jurisdiction under the purview of protective principle. So Nicaragua object to this application of protective principle under international law and asked the ICJ to decide. However, the ICJ decided that protective jurisdiction has never been prohibited under international law. But the decision of the ICJ in that case is very controversial because one cannot, the effect of the alleged crime to be committed by a citizen outside the territory of the state which claims jurisdiction, that state which claims jurisdiction over the perpetrator must prove that if the crime have been committed by the perpetrator, it will affect its national interest. So how that particular state to prove that should the crime have been committed, then its national interests will be affected. Which scale of the which scale of the effect might have affect its territory or its people or its national interest. So this application of protective principle under international is very controversial, because we cannot foresee the impact and also the effect of a crime which is to be committed outside state jurisdiction might have impacted the state which claims jurisdiction under protective principle, right? So, however, there is an existing decision by the ICJ made in the case of Nicaragua, where protective principle is allowed under international law, but it is very controversial, right? Hope that answered the question.
All right, thank you, Dr. Farid. Now to the next one from Ms. Hanis Yasmin. Doctor, there has been a number of instances where the immunity given to diplomats is abused, from minor offenses like speeding tickets, running down cases to major offenses. My question is, how can the abuse of immunity be curtailed without affecting the sovereignty? Do you think there is a need to revise the VCDR, or is there any other suggestion from your point of view, perhaps?
Now, immunity accorded to the diplomats and also the Troika is customary international law. It has been practiced for hundreds of years, right? And this customary rule of immunity has been accorded and has been crystallized and codified under the VCDR. Right? So 192 out of 193 states have become parties to the VCDR, and again it becomes constitute customary international law for the second time. Now, on the point of whether this immunity has been abused or not, it has never been abused, because immunity has already been there, right? So whatever happened during the tenure of the Troika will be protected by this immunity. But again, as I mentioned to you, the ICJ in the case of arrest warrant decided that this immunity, according to the diplomats or the Troika, is procedural in nature. The sending state may take back or may waive the immunity according to the diplomats and to the Troika, if in their view or in the state view that the immunity accorded to the diplomats and to the Troika has been abused. Right, so it can be waived, but logically, state will not waive immunity, right? Because when they waive the immunity accorded to their heads of state or the diplomats, as if they are surrendering their sovereignty and to be decided by foreign country, right? And the second part of the question, that can VCDR be revised? My answer is VCDR can be revised, or any treaty can be revised, because it has been made by the parties, right? By state representatives. If the UN convene another United Nations Diplomatic and Plenipotentiary conference to discuss on the amendment, right? And if any provisions under the treaty explains or mention on the amendment or procedures to amend the provisions under the treaty, then it can be done, right? If it is not been mentioned under any provisions under the said treaty, especially under the VCDR, then the UN may convene another diplomatic conference, invite all state parties to come and discuss whether they agree to amend the provisions, especially on the principles of immunity accorded to the diplomats or the Troika. Only then it can be amended. Okay. Hope that answered the question.
Thank you, Doctor, for that concise answer. Now, from Ms. Adiba Nabila, Doctor, what are the limitations of the family members in Article 37, Clause 1 of VCDR? Does illegitimate child includes?
Now, under the VCDR, immunity only applicable to family members. So who are these family members? It will be applicable to the wife and also to the kids, right? To the legitimate kids registered, right? So as long as, although the kids, right, of the diplomats are adopted kids, as long as their names have been registered and the names have been approved by the state, by the sending state, then this adopted child will be protected under immunity. So before a diplomat to be sent abroad, the embassy will require, or the receiving state will require, the names and also how many staffs, how many family members will be sent by the sending state. Right? So only those names approved by both countries may be protected under the VCDR. Right? Outside the names, then they will not be protected. Right? I hope that it answered the question.
All right, thank you, Doctor. Does anyone else wanted to ask any question? You may unmute your microphone and ask the question yourself.
Yes, I have a question to Dr. Farid.
Yes, please.
My name is Muhammad Ridwan bin Talib. I'm a master student from FSU. Actually, I have a few questions. But before that, I just want to add to Dr. Farid's presentation. I think there are some important points that Dr. Farid may have oversaw in his presentation. I just want to add, not to correct his presentation. Dr. Farid in his presentation had touched on the issue of extradition, and he made a special reference to the Malaysian case of Mun Chol Meong, which is a good example. But, however, I just want to add to Dr. Farid's presentation that number one, I believe that if you happen to read the decision by Kuala Lumpur High Court in Mun Chol Meong's writ of habeas corpus application, Malaysia is actually no longer referring or relying to the Extradition Ordinance, because we are now currently relying to the Extradition Act 1992. And also, one of the points for Mun Chol Meong to resist the extradition request to the United States is because his extradition request was of political nature. And this is specifically stated in Section 8 of the Extradition Act, whereby the requested country, i.e. Malaysia, may refuse or may deny the requesting country, i.e. United States, the extradition request if the offense alleged to be committed by the person in question is of political nature. I think this also applies in the case of Dr. Zakir Naik, whereby Malaysia had refused the extradition request by the Indian government. I just want to add to your point, to your presentation, Doctor. And also, you have also, Dr. Farid, mentioned about, this is because you're responding to a question regarding diplomatic immunity given to the diplomats. You mentioned about the possibility of sending state, for example, Malaysia, sending state, waiving its the diplomatic immunity given to Malaysian diplomats and sending that diplomat in question to be tried in another state. And your question is that, your answer is that that is very unlikely to happen because it is akin to surrendering Malaysia's state sovereignty. On this point, I have to disagree. Because we have a case involving a Malaysian attaché with the ranking of Malaysian diplomat by the name of Rizalman Ismail. He was at that time was working as Malaysian attaché to the Ministry of Defense. He was accused and also charged for the offense of sexual harassment and also attempted rape against a local woman. And what happened in this case was that the Malaysian government had recalled him to Malaysia, and that was seen as an escape route by the New Zealand government. What happened is that Malaysian government had stripped off Rizalman's status as a diplomat and repatriated him to New Zealand to face his charges. So in this case, it is clear that although Malaysia had stripped off our own diplomats of his position, of his privileges and immunity, that does not equal to giving away or surrendering our sovereignty. So this is just my point of view, because we have a case. And the third part, finally, I have a question, because you also mentioned about, again, with the issue relating to diplomatic immunity. I think one of your students also mentioned about diplomatic immunity given to diplomats. So I am referring specifically to the Vienna Convention on Diplomatic Relations 1961, because it was mentioned in your slide. I'm referring specifically to Article 37 and also Article 39. Article 37 Clause 1 and also Article 39 Clause 3. As I understand, that the Vienna Convention on Diplomatic Relations were built upon the legal theory of functional necessity, meaning to say that the diplomatic immunity given to diplomats because of their functions as a diplomat, that is why they are protected in the first place. Now, this resonates to the question by one of your students: why is the family members of a diplomat is given the same immunity? Because they are not functioning, they are not performing any diplomatic duties. That is my question number one. Why is that given? If that is the matter, does this contrary to the legal theory of functional necessity of which the Vienna Convention on Diplomatic Relations was built upon? Number one. Number two, when the scope of diplomatic immunity is enlarged to encapsulate those who are not diplomats, those who are not part of the diplomatic mission, will this lead to abuse of their immunity? So if that is referring to Article 37, Clause 1, and if you refer further to Article 39, Clause 3, that immunity persists even after, in the case of the death of the dead diplomat, the family of the diplomat still enjoy the same amount of immunity until up to a certain period. So, do you agree that this wide scope of diplomatic immunity given to the family members of the diplomat will lead to the abuse of immunity? And if your answer is yes, how could we do, or how to resolve this issue of abuse of diplomatic immunity? Thank you.
All right, thank you. Now, the 3 points raised by Mr. Ridwan are very interesting. Now, number one, on the political argument raised by Moon Chul-yong, right, when the US requested the Malaysian government to arrest and surrender and extradite him to the US. So he was saying that, and he was arguing that it is to be made under political persecution, right? He is to be tried because of the difference and also based on political persecution. Now, I would like to point of political abuse, right? So if or should Malaysian government arrest Moon Chul-yong to the US? Now, many extraditions requests made by many countries, the perpetrators will always contest and argue to the court that should he to be extradited to the requesting state, then he will be prosecuted based on political prosecution, right? Or, for example, contoh, I give you another example, like Sajjad, for example. He runs away to the US, let's say, to Australia. Let's say Malaysia and Australia has extradition bilateral treaty. So definitely he or she will argue that should Australia arrest and surrender him or her to Malaysia to face criminal charges to Malaysia, if any, then she or he will argue that, you know, she or he will be prosecuted based on gender bias prosecution. So that is under persecution issue under international law. So that is why political defense in so-called when extradition request has been made will always be used by the perpetrator or by the accused person, because that will be the only valid reason for him or her to make an implication before the court, so that the court will not grant a leave so that he or she will be arrested and to be extradited. Right? So that is normal under international law, that, if he or she to be extradited, then, I will be judged not because of I have committed crimes, but because of political persecution or based on other persecution reasons. Right? So this is normal under any crimes, in any parts of the world. It goes to the issue of Moon Cho Kyung just now, right? And the second point on the case of Rizalman, where the Malaysia has retracted the immunity accorded to him. Now, this is, we have to remember, as I mentioned to you earlier, that if any sending country waives immunity of his or its diplomats, then it is as if the sending state is surrendering its sovereignty, is only applicable to the Troika, right? Because the Troika, the head of state, the prime minister, and also the foreign minister, and also the diplomats. The diplomats here, to be interpreted as the ambassador, is represents or reflects the state itself. So if the sending state waives immunity according to this ambassador or the Troika, it is as if the sending state is surrendering its sovereignty. In the case of Rizalman, where this attaché at the Minister of Defense has been waived his immunity, this is not the Troika that I was meant to, but he is part of the diplomatic mission, right? So when the sending state, i.e. Malaysia, waives his immunity, this is not as if that Malaysia is surrendering its sovereignty, because Rizalman is only a diplomatic attaché, not the ambassador of the country in that receiving state. So that is two different situations. With regards to Articles 37 and 39, on the functioning of the ambassador or of the diplomats, why should we accord and give immunity to the family members? Right? So we have to understand that if immunity cannot shall not be accorded to family members of the diplomats, then it will deprive on the smooth sailing of the works of the ambassadors of the diplomats, because he or she will protect and will be in trouble due to the criminal charges to be faced by his or her family members. So it will deprive the smooth sailing of the works or the functions of the ambassadors or the diplomats. So that is why the representatives, when the VCDR in 1961 was convened, the representatives of many countries also would like to extend and agree to extend the application of immunity to also be applicable to family members, right? But again, it leads to abuse, right? As some of the students and also Mr. Ridwan has mentioned earlier. So sedap lah family members pun boleh buat suka hati lah. Nak parking kereta suka hati, nak langgar orang suka hati, right? To kill someone, right? But again, you have to remember, the sending state may waive the immunity, right? As in the case of Rizalman just now, if the sending state decided to waive immunity accorded to family members, and it can be done, because when waiving the immunity accorded to family members, it is not as if the sending state is surrendering its sovereignty to the receiving state, right? But during the tenure of the diplomats in the receiving state, immunity is agreed by the representatives when the VCDR has been agreed by the representatives of the countries when the VCDR was adopted in 1961. All representatives agreed that the same immunity should also be accorded to the family members while the diplomats are in the office, so that the functioning of the diplomats shall not be hindered due to the family members' issues. but yet the sending state may still waive the immunity accorded to family members at any time. Right? Should abuse has been found and should complaints have been made on the abuse of immunity accorded to the family members. Right? Hope that I have answered and respond to Mr. Muhammad Ridwan's and also questions raised by the students. Thank you.
Thank you, Dr. Farid, for that impactful answer. Now, is there any more question? You may unmute your microphone. We open for last question, I suppose.
I have a question.
Yes, please.
Okay. Thank you, Ms. Shaza, and thank you also to Dr. Farid for your explanation regarding the jurisdiction and immunity. Before that, am I audible? Like my
Yes,
voice
very
is
clear.
clearly? Okay, thank you so much. So my first question is that what you mentioned about tests that will be conducted between the parties for the case of Blocker B. So are you mentioning the test is actually regarding the principle, or is there any other test that will be conducted in order to determine which country that have the jurisdiction over that matter? And second one, I have the question regarding the nationality as well as the passive personality principle. How to differentiate between these two principles of nationality as well as the passive personality? That's all my question. Doctor, you are mute. Yes.
Sorry.
Mm-mm.
Now, for with regards to Lockerbie case, many states are contesting or were contesting on to claim jurisdiction, because the US will definitely claim jurisdiction because the territory where the crime was committed was on its territory, i.e. the Pan Am flight was the US registered flight. So that is US territory, right? So territorial principle is applicable there, right? But territorial principle also to be applied because before the bombing took place, the setting up of the bomb has been done in Germany. In Germany. So Germany also claimed jurisdiction. All right, although the bombing took place somewhere in the UK's territory, but the commencement of the crime started on the territory of Germany. So Germany also claimed jurisdiction on territorial principle. Now, the UK also claimed jurisdiction because the bombing took place not only on the territory, on its territory, remember the airspace, but when the bombing took place, the flight fell down and hit the grounds and killed 11 of its citizens. So the end of the crime committed on the UK's territory. So the UK also, via the Scottish authorities, also claimed jurisdiction because the bombing killed its citizens. All right. So the territory took place on its territory, right, of Scotland. So since the contest, because 3 countries are contesting on the jurisdiction, so which country is to have jurisdiction? So that is why it must be decided, right? So which state to have jurisdiction? So when the 3 states, the UK, Germany, and also the US, agreed to bring the case to the ICJ, so the ICJ decided that we have to look at the objective test of the territorial principle. Because in order for a country to exercise jurisdiction, we also have to look on the availability of the evidence and also witnesses to the crimes. So since the crime committed on the territory of Scotland and the plane crashed on the territory of Scotland in the UK, the evidence can be found within the vicinity of the UK territory. So that is why the ICJ decided that the UK court may exercise jurisdiction because of the evidence that can be found and the witnesses who have witnessed the killing of the fell down of the flight, and also the killing of the Scottish citizens or the UK citizens at the time. So there is on that basis the ICJ decided as such, right? So now on the nationality principle, and also on the passive personality. Now, nationality principle here all refers to the nationality of the perpetrator, right? Or the criminal. So passive personality is the victim, right? So this is how you differentiate between the two. So nationality is not the nationality of the victim, but the nationality of the perpetrator, right? So if Malaysian citizen committed a crime in Indonesia, for instance, right? So the Malaysian court may exercise and may claim jurisdiction because the perpetrator is Malaysian citizen, but the issue will be contested, or the jurisdiction will be contested on which territory that the crime has been committed. If the crime has been committed on the territory of Malaysia, the perpetrator escaped and ran away to another territory, i.e., for example, to Indonesia. Indonesia cannot exercise jurisdiction. Why? Number one, because the crime has never been committed on its territory. Only the perpetrator has been found on its territory, but the law of Indonesia has never been breached by the perpetrator. Right? So in this sense, Malaysia may claim jurisdiction, but only if the perpetrator is present within Malaysian territory. Right? So it goes back on the whether the perpetrator or the accused person can be found and can be arrested and can face criminal charges within its territory. And also, if it cannot, then whether there is a bilateral extradition treaty between the two states, so that the perpetrator can be arrested and can be extradited back to its to its country, right? So that criminal charges can be condemned. All right.
Thank you, Doctor.
All right, thank you, Dr. Farid. And that remarks our last question for today. Well, now, if there is no more question coming, I think we can now draw the curtain for the Q&A session. And before we end our talk today, we will proceed with the photography session.
So I will be the one who conduct the session for photography. So everyone will be given 1 minute to ready with your hijab.
Your hijab. Dr.
Hijab,
Hasbi,
whatever it is.
Dr. Hasbi, where is your hijab?
Sorry.
Baru nak pakai, sekejap lagi pakai.
Okay. We'll wait for a moment. Okay, I guess that's all. Okay, everyone smile. 1, 2, 3, smile. Okay, once again, 1, 2, 3, smile. Okay, one more time. Last, 1, 2, 3, smile. All right, thank you, everyone.
Terima kasih semua. Thank you everyone. Thank you Dr. Farid.
Right. So if any of you would like to have the slides, I will share with Miss Nadira later on.
You can also share. You can also share with me. No problem.
Okay,
Dr. Farid.
sure. Right. Thank you all, and enjoy your dinner. And for those who are celebrating Christmas, Merry Christmas.
Thank you very much.
Thank you.
Thank you, Doctor.
Thank you very much,
Thank
Dr.
you,
Muhammad
Doctor.
Farid.
Have a nice weekend, Doctor.
Bye.
Thank you.
Nice.